Hello and welcome everybody to our very first Q&A session. So for those of you who don't know, I am Michael Cressey. I've been at Bracious for 10.5 years and I'm a specialist court of protection practitioner dealing with mental capacity, court of protection and lasting powers of attorney. I'm joined by my colleague Alexandra Gordon, who is qualified. She is qualified as a solicitor, a chartered tax advisor, a notary, and on top of all of that, she is president of the Kent Law Society. So I'd like to say we are in safe hands this evening with you, Alex.
Thanks, Michael.
We will start with the will. So Alex, before we go on to the questions, can you just explain to everyone very briefly what is a will?
Yes, of course, Michael. So will is a legal document that you put in place which decides how your assets pass on your death. If you don't have a will in place, then your assets will pass in accordance with the intestacy provisions. And that doesn't always mean things pass in the way you would think. So, for example, not everything necessarily passes to a spouse, and if you aren't married, then nothing would pass to a cohabitee or partner, even if you've been with them for many, many years. A will is also a good place to put in guardians for minor children, and also in your will you would appoint executors, and their role is to look after your assets and your estate and make sure everything passes in accordance with your instructions in the will.
Fantastic. Now, before we go on to the questions in relation to wills, I'll briefly touch on what a power of attorney is. And quite simply, a power of attorney is a legal document which you can prepare, which enables somebody else to act on your behalf if you A, need assistance, or B, cannot act of your own accord. And there's two types. The most common, the financial power of attorney, and the least common, but ultimately more important, is the health and welfare document. So Alex, moving on to the questions. Our first question for you this evening. This is a silly question, but where do you start with a will?
There are no silly questions, so ask away in the chat if you have any questions as we go. So where do we start with a will? So we have an online wills questionnaire which we send out to clients in advance of any meeting. The reason for this is twofold. One is to make sure that we keep the meetings as brief as possible because we know your time is very precious. So the more information we have beforehand, the better. Also as well, it will give you an idea as to what information we need when dealing with a will. And sometimes that's not information that you may have to hand or knowledge of in a meeting. So it gives you prior knowledge of what we might need. And for example, just because we're making a will, it doesn't just stop there. We will look at how you own your assets. We will look at pension assets. We will advise you on inheritance tax as well. And then we will look at the terms of the will. So there is a lot of advice going into any meeting that we would hold with you. So the first step is we'd send out a questionnaire. And once we had that back, we would arrange a meeting virtually if preferred, or in person, and we would run through your family structure, your assets, advise on how they will pass. Not all assets pass via a will, touch on inheritance tax, and then we would run through what your will can look like.
Excellent, thank you very much. Now, another question we have here, which is quite a common question, which is what do you need to consider when making a will as a married couple?
So we don't tend to come across a normal family anymore. So there aren't normal families with 2.4 children who put wills in place very often. So first of all, we look at the structure of your family. You may have children from a previous relationship. You may not be married. And we look at how best to structure your assets to make sure that everyone is looked after in your will. We also look at how you own your property. Sometimes property will automatically pass to a co-owner, therefore it won't pass via your will. So we would advise you in respect of that. And also as well, some people are concerned about care home fees and protecting monies for the next generation down. So when looking at the ownership of your property, we would look to see whether there's any ways of protecting maybe 50% of the share of the property for the next generation down, rather than it being up for grabs by the local authority for care home fees at a later date. We also look at, if you have children, the ages of any children and when they inherit. And if you don't have children, who your default beneficiaries would be if something would happen to both of you. And the meeting would cover anything and everything you wanted to discuss, very wide, and we'd make sure that you've given all the options available to you based on your circumstances.
Fantastic, thank you very much. Now, our next question is quite in depth, and a couple of people have asked this actually. So it's how to draw up a will to include provision for children under the age of 18 and to avoid them inheriting everything immediately at the age of 18.
So if you have children, it really is important that you put a will in place, and that's for two reasons. One I touched on earlier is guardians. If you've got children under 18, your will is the best place to appoint guardians of those children, and that would mean that if anything happened to you and their other parents, the other person with parental responsibility, then they would have someone legally entitled to look after them under the will. If you don't put that in place, then there is a possibility that it could end up with the courts, and they would decide who look after children in the absence of that. So guardian clause is really, really important. If you don't have a will in place, and money is left to children under the intestacy provisions, then the money will go to them at the age of 18. And a lot of people think that is very young, especially if they have lost their parents as well. It's not a good time to be leaving large sums of money to children. There are a few options when it comes to children. So if I break it down simply into two main options, one is at a specific age and the other is via a trust. So in your will, you can state what age you would like your children to be when they inherit, and that could be whatever age you want. So 21, 25, whatever age you think is best. It doesn't mean that the children don't get any money until they reach that age. It just means they won't get all of the monies until that age. Before that age, they can ask the executors for monies towards anything they may need, so their education, their health, their maintenance, and if the executors think that's reasonable, then they can provide monies out of the monies held for them in advance of them turning the age that you've put in the wills. The other option is more of a trust structure, and in that trust structure, trusts become quite complicated, but to put it quite simply, in that trust structure, you can either decide that your children receive income only at 18, or they don't receive any income at 18, but when they get the capital, it's completely up to your executors. So the executors will be people who you trust. They will become the trustees of the money to look after it for the children whilst they are young. And it will be the trustee's responsibility to decide when is a good age for the children to inherit. So you won't have specified a specific age. You will just have said to your trustees when you think it's a good time for them, probably around 25, say, for example. Your trustees will then look at the children's circumstances at that time and decide whether that is a good time for them to have monies. Just because a child is 25 doesn't mean they aren't going through a divorce, or doesn't mean they don't have money problems. So it might be your preferred age is 25, but we haven't put that in concrete. We've left it up to the decision of the trustees and said to them, we would like the money to go to them at 25, but if there's reasons not to, please don't. So at 25, the trustees will look at the circumstances of the children and say, right, actually at this stage, child A, completely fine to have money, they're about to buy a house, let's give them their share. Child B, let's hold on a bit because their circumstances aren't right for them to be receiving a lump sum of money. So it allows a layer of protection, and normally that is the option that people prefer because we can't see into the future. We don't know the circumstances of our children, what they will be in 5, 10, 15 years time. So by not putting a specific age on it, it does allow the trustees, the people you trust, to use their knowledge of the situation, their knowledge of the children, the knowledge of the assets, and decide what's best at the time. So for children at the moment, most people do put in place a trust structure and leave a little bit of flexibility.
Excellent, thank you very much. And our next question is quite an interesting one, actually. When you inherit a house and then you sell it, if you own your own house, do you then pay inheritance tax and also second home tax?
So if you own your own property and you inherit a house, there may have been inheritance tax on the estate of the person who's passed away for you to inherit. that second property. That's normally dealt with in the administration of the estate. So it's very unusual for you to inherit a house and then have to pay the inheritance tax due on it. You'd normally receive any asset free of inheritance tax. If you're then owning two properties, so your main home and your second property, if you sell your second property in the future, there may be what's called capital gains tax on the sale of that property. And it will depend on when you sell that property and whether it's gone up in value. When you inherit that second property, you inherit it at its market value. So if the market value on the date that you inherited it was 300,000, and you sold it for 300,000, then you've sold it for the value that you inherited it at, and therefore there's no capital gains tax. You do get an allowance from capital gains tax, but if say for example, the property sells for £350,000, we've got quite a large gain on that property, you will use up your annual exemption against capital gains tax for the year, and any gain above that you will pay capital gains tax on, and that will either be at 18% or 28%, and it's based on your own income tax rate. If you've got a spouse and you're owning that second property with a spouse, or you decide to gift your spouse half of that second property, then you will have two people disposing of it for capital gains tax, and therefore you've got two annual allowances to set against that capital gains tax, so it reduces the amount of tax down. I'll just touch on stamp duty, just in case this question was trying to cover that as well. If you're inheriting a second property, you don't pay stamp duty on inheriting the property. It's only if you own your main home and then you buy a second property that you will pay that extra 3% stamp duty tax. So you don't pay any stamp duty when you inherit a property.
Excellent, thank you very much. And next question is a really good question, actually. What are the concerns of doing an online will without the support from a solicitor?
Not trying to plug solicitors here. I'll just give you a few top tips. So first of all is that if you're making your own will, you are making it with the knowledge that you have. So you are deciding what clauses are best for you in your will. If you came to a solicitor, we would have quite a full meeting about all the different options available to you and the different trust structures that can be put in place. So your will be drafted based on advice that we give you based on our knowledge of wills, assets and trusts, and also fitting it in with your exact circumstances. So we're able to offer that extra advice on what the best way to leave your assets is. Secondly, we will advise on what assets pass through your will. So if you own your property jointly, you may own it one of two ways. The first is called joint tenants, which is how most married couples own their property. And the second is called tenants in common. Now, they both mean you own your property jointly with your co-owner, but joint tenancy means that if anything happens to one of you, the property will automatically pass to the survivor. So it won't matter what your will says, the property will automatically pass by law to the survivor, the legal owner. So when we give advice, we give you advice on that. We will look at how your property's owned, and we will work out whether you're happy with it passing directly to your co-owner, or whether you would want to change the position to tenants in common, which means that your 50% share of the property can pass via your will. And we do that quite a lot when we're looking to protect part of the property for care home fee purposes. Talking about other assets that don't pass via your will, pensions that have been nominated won't pass via your will either. So there's the danger if you're making your will yourself that you're including assets in your kind of thoughts as to who's going to get things in your will when actually they won't pass via that. So that's something to be aware of as well. And then I suppose, not that I've ever had any complaints or been sued, just to put that out there, but if we were to put your will in place, or any solicitor was to put your will in place, we have insurance. So if anything goes wrong in the future, we are there, our insurance is there to cover any mistakes made. And with law firms, solicitors firms, if anything happened to a law firm, they will get bought out by another law firm, because their will bank is very precious. So solicitors always get bought out. So, I mean, it's very unlikely with Bracious. We've been going for 125 years, so very unlikely with us. But with other law firms, you do hear of law firms closing, but another law firm will always buy out their will bank and take on the responsibility of any wills. With will writers and other companies that put wills in place, they won't have that same level of insurance, and also they may not be around if there is a problem in the future. So there may be no comeback on anyone if something's gone terribly wrong in the will. And whilst people think wills are very simple documents, if they go wrong, they do go very wrong. So it's definitely best to get a professional and put it in place properly.
Excellent. Thank you very much. Nicely answered without plugging solicitors too much. Next question. How does leaving money in a will within a trust fund work?
So a common misconception with trust funds is that you have to set them up in your lifetime. You can, but you don't have to. So if you made a will today with a trust fund in it, it will not come into effect until your death. So you've not set up a trust fund in lifetime, you've not had to pay for that, you've not had to pay for any administrative charges of that trust fund. It will not come into effect until death. Now, as I said, there's mainly two different options when it comes to trust funds. One is called a life interest trust, where you give the right of enjoyment of an asset to someone. So that can be the right to income if it's a bank account. It can be the right to live in a property. But basically, you're saying to them, you can enjoy it for your lifetime, but I want to make sure that the capital is protected for someone else. Now, we see this a lot where people want to protect monies against care home fees for the next generation down. And we see it a lot where people have children from different relationships. They want to make sure that their children receive their capital, say in the property, just in case the survivor of them falls out with the children or they change their will as they get older. They want to guarantee that if something happens to them first, their 50% share of the property or all assets is earmarked in a trust structure for their children, but the survivor of the couple is allowed that right of enjoyment, so they can live in their 50% share of the property for the rest of their life. They've got that security. They're going to have the income from any bank account, so they've got that income coming in. So that's normally a very popular structure between married couples or cohabitees to make sure that the survivor's protected during their lifetime, but the capital doesn't then move away from the first person to die's chosen beneficiaries, whether they be children or other people. The second main type of trust is called a discretionary trust, which we touched on earlier when we talked about children. And with that trust, it's basically putting a protective wrapper around all of your assets and saying to your trustees, we want you to deal with these assets in your complete discretion as you think fit. And whilst that sounds a bit wishy-washy, it's probably the most popular structure, especially when we're dealing with children, because at the moment, none of us know when we're going to die. We don't know what assets we will have at our death. We don't know what the succession rules will be, what the trust tax rules will be. We don't know if trusts will exist in the same way as they do now. So by putting everything in this discretionary trust wrapper, it gives your trustees the flexibility to look at everything: the children's circumstances, how old they are, whether they're mature and responsible. It allows to look at the assets, what assets we've got. It might be that there is a property which would be good to pass directly to a child rather than sell. And it also gives them an idea of what the tax rules are at the time, so they can look at everything and say, right, actually this is the best structure, or actually no, it's not quite right based on the tax rules right now, let's change it slightly so that we can minimize taxes and keep this trust running for the protection of the children. So it allows us to it's like a wait and see. You put everything wrapped up in this structure and allow your trustees the flexibility with the knowledge that they will have at the time to work out what is best. I won't go too much more into trusts because they can get complicated, and I don't want you all to leave before Michael talks.
Excellent. Thank you very much, Alex. We will now move on to powers of attorney. Again, if anyone has any further questions as we go along, please do pop them in the questions section on your screen. So the first question I have here is, my LPA is 15 years old. Do we need to change to the new style? I'm assuming, although one really shouldn't assume, that by your LPA you mean an enduring power of attorney, but I'll talk about the two. So if you have an enduring power of attorney, this is the older style power of attorney form, and I would highly recommend updating from an enduring power of attorney, an EPA, to a lasting power of attorney, LPA. The EPA only covers your financial affairs and it isn't registered. Your named attorneys have the responsibility, so the onus is upon them to register your document, your EPA, when you start to lose mental capacity and not before. With the new lasting powers of attorney, there's again two types, the financial one and the health and welfare one. The financial one supersedes the enduring power of attorney. It's signed and registered immediately. Your attorneys can use this document even if you still have your mental capacity. So if your illness was perhaps a physical illness where you'd broken your leg, or you was quite simply shielding from COVID, you can say to your named attorneys under the new LPA for your financial affairs, I can't quite do this. Can you go down to the bank and do XYZ for me? Can you phone up this utility company and do XYZ for me? And they can. So they're using the document under your consent and with their instructions. The next question we have here is, what happens if you have gifted money to relatives, but then you have to go into a care home? Very good question, and quite a common question, actually. Gifting money is becoming more and more popular. Now, people are scared to gift in light of what's going on with more people having to go into care homes. Now, when you go into a care home, you'll have an assessment done. This assessment is two-part: a needs assessment to ascertain the level of care that you need, and a financial assessment to ascertain how much and who pays. If the local authority, care home, whoever, believe that you have deliberately deprived yourself of that asset, so say you gifted away £10,000. If the local authority deliberately or thought you deliberately gifted that, then that would come under a deliberate deprivation of assets. You're giving away your assets so you don't have to contribute and fund your own care. In that situation, the local authority can actually reclaim that gift money, £10,000, from the beneficiary, which will obviously cause a lot of unrest, a lot of anxiety, and cause a lot of issues. You can gift on customary occasions as well. So if you have normal, say like birthdays, Christmas, Easter, weddings, university, etc., you can make normal gifts because that's a valid reason to do so. Next question here, which I'm just reading. Michael, you did our power of attorney for my father. Please tell me about the financial and health ones for myself. Yeah, I think I've very briefly touched on that. Powers of attorney, lasting powers of attorney, there's two types you can prepare, the financial one and the health and welfare. So just diving in a little bit deeper to those, the financial one, your attorneys can do everything that you can do on your behalf. So if you ask them or you've lost capacity yourself, your attorneys are able to have access to your bank accounts, your current account, your savings, if drafted correctly, your investments as well, and buy and sell property on your behalf if you cannot do so or you ask them to. The health and welfare document, again, it's signed and registered immediately so that it's ready for use if needs be, but it's slightly different to the financial one. The health and welfare is decision specific. So again, you would nominate people to act on your behalf. Health and welfare, it covers the real basics, so what you wear on a daily basis, your dietary requirements, going up to what medication you receive, what care you receive, and also life-sustaining treatment. But your attorneys can only make a decision or act on your behalf if it's quite clear that you cannot do so yourself of your own accord. Just by way of an attorney acting under a health and welfare power of attorney, and for a great example, but taking worst case scenario, you have your health and welfare power of attorney appointing, say, your spouse and your 2 children. You're rushed into hospital and you're unconscious. You cannot make any decisions for yourself. The hospital staff are talking about life-sustaining treatment. You can't say, yes, hook me up, or no, I don't want to be hooked up. Your attorneys under the Health and Welfare LPA can make a decision as though they were you in relation to resuscitation, life-sustaining treatment. So it's important that if you do have a health and welfare power of attorney, express your wishes to your attorneys. Either jot it down on a note, sign it, date it, or verbally express your wishes to them. What that will achieve is, going back to that situation and an example, if you're unconscious, you can't say, yes, hook me up. Your attorneys would have the right, as an attorney under the Health and Welfare LPA, to say, yes, it was Michael's wish that he shall be hooked up to life support, or it was Michael's wish, for whatever reason, religious or not, that he not receive life-sustaining treatment. So you can see that the health and welfare, even though it's not as common as the financial one, it is just as important. So I hope I've answered that question correctly and what you was anticipating. Moving on to the next question. I already have a financial LPA. Do I need a health and welfare LPA too? Well, I think I've sort of answered that with the above question. Certainly my advice and recommendation would be to prepare both lasting powers of attorney, so the financial and the health, just to cover you for all eventualities. If you do have an existing power of attorney, it might be worth just reviewing that, just to make sure all your attorneys are who you want them to be. And of course, you can include specific instructions, and also prepare sort of a side letter of wishes as well to accompany that. Powers of attorney, they are legally binding. Letters of wishes are not legally binding. It's guidance to your attorneys to assist them in acting, should they need any assistance or guidance. Next question here. My father has an LPA for his financial affairs, and the attorneys are appointed jointly. Is there an issue with this? Potentially, yes. So the way attorneys are appointed within lasting power of attorney documents, if you have just one attorney, obviously they're appointed just as a sole attorney. If you have more than one, say 2 or 3, there's 2 ways that you can be appointed. Jointly, which means that all your attorneys act together, make decisions and agree together. The second and most flexible here is jointly and severally. So if you have 2 or 3 attorneys, the ideal way, and my recommendation and advice, would be to appoint them jointly and severally, which means that they can all act together, but they can also act on their own. So if one of your named attorneys cannot act for whatever reason, whether they have passed away, whether they've lost capacity themselves, whether they're ill at that certain time or out of the country, the other remaining attorneys can still act for you. Going back to your question, they're appointed jointly. If one of your father's attorneys has passed away, lost capacity, or simply can't act, then all attorneys can't act because they're appointed jointly. So I hope that answers your question there. The last question that we had, which was pre-submitted, again, if you have any questions as we're going along, pop them in the question section. Last question here: how long does it take to prepare a power of attorney? How long's a piece of string? The legal documents can be drawn up in a matter of days. We'd like to say at Bracious that we get drafts out to you to approve within 7 working days. The process behind powers of attorney is that they're prepared, they're signed by the person who's preparing them. So if I'm preparing a power of attorney, say appointing Alexandra, I would be the first person to sign my power of attorney. Then a professional needs to sign in capacity as a certificate provider. What that means is it's either a professional with the relevant skills like us at Bracious, or somebody who has known you personally for a period of 2 or more years. They're second to sign. After you and the certificate provider have signed, the attorneys can sign in any order. Once the signature process has been done, the document is sent off to the Office of the Public Guardian, which is the governing court, who register them. That is where the delay occurs, unfortunately. At the moment, from initial instructions to completed documentation, so start to finish, we're saying on average about 2 months, 2.5 months. Now, obviously, that's some of that is due to the COVID backlog. But if you do not have a power of attorney in place, so just for an example, if you do not have any financial power of attorney in place and somebody loses capacity, it is then too late to prepare a lasting power of attorney document. A relative or close family friend would have to then apply to the Court of Protection to be appointed as your financial deputy. So now we're moving away from powers of attorney and going in to the Court of Protection world. The Court of Protection world can take anywhere from 6 to 8 months to complete, and there is about 10 times more documentation to complete because it's a formal court process. There's court proceedings. With lasting powers of attorney, it's a legal document, so it's a deed, and it only gets sent to court to be registered, compared to the Court of Protection, where you have to open proceedings, notify relevant people, and then go along with what the court and the judge say. So if you want peace of mind and be in control of who you want to act on your behalf, if you cannot do so yourself, then it's vitally important to prepare a lasting power of attorney document. I hope that answers all of your questions. Alex, did you have something else with your hand popping up there?
Yeah, sorry, I don't know how to use the technology. So I just wanted to just to say something, which I probably should have said at the beginning. So your wills will only come into effect on death, and your lasting powers of attorney will be in effect during your lifetime. So they will never come into play at the same time. And it's normal that your attorneys in your lasting power of attorney would be the same people as your executors in your will, because they would have full knowledge of your assets. Now, you obviously need both. It's best to put both in place. They are very different though. With a will, it's very easy to amend. So a will we would have in a Word document. If you wanted to make any small changes, we can easily do that, reprint the will, and you would re-sign. With powers of attorney, they're slightly different. They're more permanent documents. And as soon as your children or your chosen attorneys are adults, that is a good time to then put them in place. Because obviously no one knows if they're going to lose capacity. So we see them like an insurance document. You put them in place and hope you never need them, but if you do, they are there ready to use. So between the two documents, they will cover every decision that needs to be made during your lifetime, and then cover where your assets go on death. But it's just the little difference in them. The powers of attorney are more permanent documents. You can't amend them like a will. You would have to revoke them and then start all over again. So you'll find that lasting powers of attorney are more expensive than wills, because they are the kind of the one-off permanent document. Hope you never need it, but it's there. With a will, family circumstances may change, assets may change, and that is more of a working document that you may look to amend every 3 to 5 years maybe. But it's easier to do so because we would have it in a Word document. So yeah, just wanted to clarify that. Thank you.
Yeah, no, absolutely. What I normally say to clients as well is the most simplest way to think about things is powers of attorney a lifetime, wills are after death. Most simplest way to do things. Alex, we have received a couple of questions here. One question for you in relation to wills is, do a husband and wife have to do wills together? For example, can one partner have a solicitor draw up a will and the other go to do it online?
We would recommend that you do it together. It's not too much more expensive to do wills as a couple than it is to do individually anyway. But what you'll find is that things will come out of the meeting about how your assets are held and how you're thinking of leaving them, that may, if we drafted just one of the wills, that may contradict how the other person is doing their own one online. So it's always best to do them together, just to make sure that the assets do marry up and the end result is not going to be a shock if something happens to one of you.
Absolutely, yeah. Another question we've received here is, we own our own property but also have a mortgage on it. If we both die, does the house have to be sold automatically to pay the mortgage off? We have 4 children and we would want to leave the house to them.
So it doesn't have to be sold. If there's any insurance policies, life policies, or monies in the bank that can cover and pay off the mortgage, then that money will be used to do that. And then the property is up to the children to decide what they want to do with the property. If there aren't any extra funds, then it will be up to the children. If the children can raise the additional money to pay off the mortgage and keep the property, then they can do that. That's not a problem. There's no automatic sale of the property. It would just get to the stage where if the money can't be raised, the mortgage company would want their monies back in some way, shape or form. So someone would either have to continue paying that mortgage monthly, take it over, or pay it off entirely.
Excellent, thank you very much. Another question we have here is, I already have an existing will in place, however, this is 12 years old. Do I need to do anything? For example, review my circumstances and the content of the will.
It's not a bad idea to have a review of the will, and we're more than happy if you want to email it to one of us after. I think our contact details are coming up. If you want to email it to us after, we're more than happy to have a look at it and have a call with you just to run through it. It may be that it's absolutely fine, and just because you need to look at it every 3 to 5 years doesn't mean there need to be changes. It's just we just need to double check that nothing drastic has changed. So within the last probably 15 years, there have been some quite dramatic changes. So you find people with wills older than that, they do want to change them to make them more simpler. There used to be a lot of trust in wills, so to make them more simpler. If we look at it and review it and everything's absolutely fine, then there's no need to do a new will just to make it more recent. And you don't have to update your will just because you've moved house or your executors have moved house or someone's got married and their name's slightly different. Things like that don't need to be updated. But if there was another reason to update your will, for example, someone had passed away, or you wanted to change who was receiving maybe certain assets under the will, then we would incorporate all those other changes when we updated your will.
Excellent. And another question we have here, I think I might take this one. I've heard of a document called a general power of attorney. Can you explain what this is? Yeah, absolutely. So a general power of attorney is still a power of attorney document. It's a lot easier to prepare and certainly a lot quicker. However, a general power of attorney is only valid whilst you have mental capacity. If you were to lose mental capacity, the document would then be invalid. So a good example as to why people use these is if they own a property abroad, perhaps they spend, say, 3 to 4 months out of the UK and they still have assets here. With a general power of attorney, and obviously they nominate someone to act on their behalf to deal with their financial decisions here in the UK whilst they're abroad. Another example for a general power of attorney is if you're preparing lasting powers of attorney and you don't want to wait the timescale, so 2 months, 2.5 months, then you can prepare a general power of attorney as an interim measure just to tide you over whilst your lasting powers of attorney are being registered with the court, and then obviously you can just revoke the general power of attorney excuse me, whilst or as and when your lasting powers of attorney are registered. That really does conclude our Q&A session. Any questions, please do get in touch, and it's an absolute pleasure delivering this Q&A session to you tonight.